I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.2. This is part 2. In the first video about this, which I hope you watched first, I went through the provisions of Rule 1.2, the text of the rule, sections A through D. In this video, I'm going to be talking to my students about the ABA's comments and the first set of comments that clarify and embellish the rule. Remember that for purposes of the MPRE and my exam, you should treat the comments as basically part of the rule. So anywhere that the comment gives an example or sort of clarifies or fills in some gaps of the rule, functionally for testing purposes, it's part of the rule. So having said that, let's look at my slides and continue with our discussion. And remember that Rule 1.2 is about the allocation of authority between the client and the lawyer. And that's a fancy way of saying who decides what. And also the scope of representation. What did you actually agree to do for this client? So first, let's talk about the client's authority, what they always get to decide, which is the purposes to be served by the legal representation within the limits imposed by law and the lawyer's professional obligation. So this means that the client is in the driver's seat about what they want, are hoping the outcome will be, or they're trying to achieve. Some lawyers will make a mistake of substituting their own judgment for the client because they think they know better than the client what would be good for the client, and that can be inappropriate, right? So if the client wants to sell their business, their family business, don't start substituting your own judgment and saying, oh, they shouldn't sell the business or shouldn't sell the family farm because it's been in the family for generations, and so you end up trying to thwart or undermine what the client was trying to achieve. Similarly, if the client's top objective, let's say in a criminal case, is to avoid going to jail at all, but they're willing to basically plead guilty to anything that doesn't carry a jail sentence and go on probation or pay fines or so forth, the client gets to make those decisions about the ultimate objective or purposes of the representation. And so you could be subject to discipline if you end up deciding that you are going to decide, work towards a different goal than your client actually wants. Now, it's a different story when we talk about the means. And sometimes you might actually disagree with them about the means to be used to accomplish the client's objectives. And remember that the client is in charge. There's no reason for disagreement about the objective of or overall purpose of the representation. The client decides that. If you don't like it, don't do the representation. It's just that simple. Now, when it comes to how we get there, the clients will normally defer to the special knowledge and skill of their lawyer with respect to the means to be used to accomplish their objectives, particularly with respect to technical and legal and tactical matters. And conversely, as I've said, lawyers will usually defer to the client regarding questions, and very much so about questions that involve the expense to be incurred or concern for third persons who might adversely be affected. So what are we talking about? Expenses? Well, whether to hire experts. If your client says, I don't want to spend a lot of money on this matter, I am not willing to hire experts or consultants or investigators or do a whole bunch of depositions. Your client may say, I don't want to do litigation. I want to do arbitration because it saves money. Even if you think you could get a better outcome at trial, this is an example where you should defer to the client if it's going to involve out-of-pocket expenses for the client, even though in your opinion as a lawyer, it could only help, let's say, to have more experts or more consultants. Now, because of the varied nature of the matters about which a lawyer and a client might disagree, and because the actions in question may implicate the interests of a tribunal or other persons, the rule does not prescribe how such disagreements are to be resolved. So if you get a test question about this, the ABA actually, the rule doesn't say, what do you do when you and a client reach an impasse about let's say, whether to go to trial or whether to call a certain witness, whether to file a motion for summary judgment before trial, whether to bother trying to get win the case on summary judgment, and things like that. If you and the client really can't agree on that, you may need to withdraw. But for purposes of test questions, the best answer is to try to come to some sort of resolution with the client, a consensus. Either decide that you can live with how the client wants to do it, even though you would prefer to do things a different way, or you're going to have to withdraw, or maybe you have won the client over. If they give you an option on the MPRE that's something to the effect of consult with the client, try to reason with the client, that's usually your first and best answer. Now, sometimes at the outset of a representation, a client may authorize a lawyer to take some specific actions on the client's behalf without checking back with the client. So let's say your client hires you to handle a matter, and then they're going to be unreachable for a while. They're going on a cruise in international waters or something like that. Or they just expect to be tied up at an event, at a conference, let's say. And so they say, go file this lawsuit. Well, for purposes of a test question, the lawyer can then act on that or rely on it without double checking with the client. If the client tells you settle this case for within such and such a range of settlement, then you can settle as long as it's within the range the client said, without checking back with the client. I'm going to tell you, in practice, it's always safer, of course, if you can double check with the client. You should. Why? Because notice this last sentence here. Even though you can rely on such an advance authorization, the client can revoke such authority at any time. And so maybe the client, in the meantime, since they told you that, has been thinking about it and has changed their mind. It doesn't hurt to double check with them. But for purposes of a test question, especially a multiple choice question that's going to ask you, was it permissible for the lawyer to rely on this, or proper, or is the lawyer subject to discipline? The answer is the lawyer can rely on authorization from a client that was expressed, given ahead of time, to file something, to withdraw a lawsuit, to make a disclosure, to transfer funds to another party or something like that. Now, let's talk about the special case of an insurance company hiring a lawyer to represent one of their policyholders. That's going to often involve some limitations, and including the scope, right? So they're probably going to say we're only hiring you to represent them in things that are covered by the policy. Now, you might have to explain this to the policyholder, because they think, oh, the insurance company got me a lawyer. This person's going to handle my divorce too, and bail my kid out of jail, and tell my next door neighbor where the property line is, and all of these things that they might wish they had a lawyer for. But if the insurer has hired you, almost certainly their representation agreement limits your representation to the scope of what's covered under the insurance policy. Similarly, if a client has very limited objectives for representation, like they just wanted to make a statement, or they just wanted another party to be on notice about something, then they can limit the scope of the representation, and then you shouldn't go any further than what they actually had intended for you to do. So, for example, some people just want to send a demand letter or just want to threaten litigation, and it's sort of an empty threat. They haven't really decided to whether to go forward, but they're putting on the other party on notice that they are unhappy. This is very common, and if that's all they want you to do at this stage is file a letter and see what happens, send a letter or make a demand to the other side, or make a threatened legal act, further legal action, then that's what you do. Now, in your agreement to provide representation, you or the client can exclude specific means that might otherwise be used to accomplish the client's objectives. Now, when we talk about like the scope of the representation, that's usually focused on limiting the objectives or the purpose of the representation, but we could also say certain means are off the table. An example would be things that the client just thinks are going to be too expensive. And so they say, I don't want you to hire any experts. I don't care if it would make it more likely that we would win. Or I don't want you to hire consultants, or I don't want to do litigation. I want to do arbitration or mediation instead, and things like that. So they can exclude those actions. And similarly, the lawyer can advise a client up front and put it in writing. There are certain things that you as a lawyer just don't do because you find it repugnant or imprudent, like talking to the media. Let's say you, in your experience, that always backfires. And so you can tell the client up front, I'm not talking to the media. If you want a lawyer who likes to do press conferences and talk to the media and do media interviews, you need to get somebody else. And so put it right in there, right? Or if you don't like doing trials, let's say you're an appellate lawyer and you agree to represent someone for their appeal. And of course, a lot of appeals end with a remand for another trial. If you are willing to do the appeal, but you really don't want to do the trial, if it gets remanded, you would rather they hire a trial lawyer, go ahead and put that in the agreement from the scope, from the start, limiting the scope of the representation and also means by which you might try to achieve it. Here's another example they give in the comments. Sometimes a client just wants general information about the law so that they can handle some sort of pretty uncomplicated legal problem. So let's say you have a client who owns a property. They're a landlord and they have some tenants, and they call you and say, hey, listen, my tenant did this. Can I evict them? Or if my tenant is demanding that I make some changes to their apartment, am I obligated to do that under the lease? Sometimes these are questions that you could answer off the top of your head, right? If you have a client call you and they say, I've been arrested, should I talk to the police? Usually the answer is going to be no, right? Don't tell the police anything. Invoke your right to remain silent. It's almost always better for you to do that. So if the client just is checking in with you, would this be legal? Or could I be liable if I do this? And you know the answer, then it could be that you've one way or another agreed that the entire representation, the scope, is that phone call. Sometimes you can give a client everything they need with a simple phone consultation and no further representation is needed. Now, of course, that's not a reasonable limitation. If this is some complicated thing that any competent lawyer would think that they need to spend a couple of weeks researching and studying and doing a 50-state survey and so forth. So if the client asks you something like, what is the law on this in every state, and you don't know, don't wing it, right? Then you could be subject to discipline. Now, when you make an agreement to limit your representation, let's say to just a phone call or to just a demand letter, it can't exempt you from the duty to provide competent representation. So you can never, let's say you have a friend who has been nagging you to help them with their case and you really don't want to do it. It's an area of law you don't do. And so they say, look, just take my case so I can tell the other side I have a lawyer, and you don't really have to do any work or you don't have to try very hard. And they're basically asking you to agree to represent them incompetently. That's inappropriate, right? So that would be a violation of the rule. But now let's talk about the limitation on the representation. Let's say they just ask you, look, all I really want you to do is make a phone call for me or send a demand letter. That's going to be a factor when we decide whether you were competent to handle the representation. And so, for example, if they really just want you to follow up and make an inquiry, let's say with the Internal Revenue Service about their tax returns and an audit that is ongoing, they don't want you to take over the whole matter, even if you don't know anything about tax law. If it's just a matter of making a couple phone calls and getting an answer for a client, you could probably do that, right? On the other hand, if the client is asking you to handle a very complex tax matter, let's say for an international corporation and so forth, then that would require more knowledge, skill, and thoroughness and so forth for the representation. Now that concludes our first round of talking about the comments to Model Rule 1.2. I have one more video about 1.2 that talks about client crime and fraud. Make sure you watch that.